I'm Jim Gordon at Beers & Gordon. I'm here with my partner, David Beers. We want to talk about pre-existing injuries. And I tell every client we talk about this. There's really three defenses to a case that we hear a lot. One is if the impact was small, the injury could never have been caused, we hear that. The next one is there's gaps in treatment by the client. They don't treat for a while. They say, could they have really been injured? But the one we almost always hear, right, is pre-existing injuries.
We always hear this one, and it's because medical science says, based on studies they've done, that everybody over the age of about 30, 35 does have some documented changes in their spines, particularly as a result of simply the aging process. And the insurance industry loves to say, well, if they have these changes and they're found on MRI, obviously they must have had pain. How could it be any different due to this auto crash?
Yeah, and that's a point that's made. I tell my clients, whether you're 20 or 80, the insurance company says it's all pre-existing. Nothing's related to what we did to you. It's all pre-existing. There's a couple things I think that are always important about that. Is, have you ever had treatment for that alleged pre-existing injury that the insurance company is claiming? Because if you haven't, the best thing we can do is show all your primary care records for the last 15, 20 years. I remember throwing him up at trial one time and throwing his stack of 17 years of records and put him on the stand and say, please, ladies and gentlemen of the jury, go review all of his records. See if he ever complained about back pain. See if he ever complained about neck pain. That gives him the opportunity to say, you cannot believe what the insurance company says in this case because the records show nothing existed. And that's a very important point.
Precisely. One of the other important factors that I think is important in terms of Florida law is that Florida law permits the recovery for personal injury damages from an automobile accident to an individual who has a pre-existing condition in their spine that has been aggravated by the forces in the crash. And many people do have aggravation to pre-existing spinal injuries or spinal conditions. And they think, well, I can't collect for anything, even though I'm in a lot more pain than I was before the crash. I might not have been in any pain at all from these pre-existing injuries, as Jim just pointed out. And so it's important to understand that we can assist in the preparation of the doctor's analysis of the client's injuries, as well as the insurance industry's analysis by pointing out that we can recover for an aggravation of a pre-existing condition.
Yeah, and that jury, we put that up all the time, that jury instruction. It need not be the only cause, it needs to be a cause. The important thing is when you're calling an attorney and you've had an accident, even if you've been treating for that type of condition and it gets worse, because that can happen. But the biggest thing I always tell clients is you have to tell us. You have to tell us because it's going to be found out. The reality is, in the days of electronic records, everything about your medical history in the last 10 or 15 years is going to be found out. And also the insurance companies share information. We got it when we were insurance defense attorneys. We got what's called an ISO report, and we found out that there had been other claims. The problem is those ISO reports are terrible because most of the time they're wrong. So we see that all the time, but it's important that we've had those discussions with people because we can explain the things as long as we know what those things are. If we don't know what your injuries are, you don't go through it, you don't tell us. And unfortunately, we've had that. We get to the point and we say, oh, you didn't tell us about those 5 other accidents. That's a problem. And we tell our clients at that point, that's a problem. But if you tell us all of the information ahead of time, we're going to gather it. We're going to be, and also if we're in a deposition, I know you do the same thing, I will go through the records with my client and say, let's talk about all your pre-existing treatment, your pre-existing injuries, so you can explain the differences.
Right.
Because that's an important part of a deposition.
That's very important to the preparation of the client for a deposition. The whole case can be lost in a deposition. You cannot frequently win a case in your deposition, but you sure can lose it.
And that's why when we used to go against the big firms when I was a defense attorney and they'd shake the hand of the client at deposition, I knew they weren't prepared for that issue. And that's why not only are we going to talk to you about that issue, but more often than not, we're going to hand you the records. And we're going to, or email them to you and say, review these records, understand what you talked about before. Because the other thing is sometimes, especially at chiropractors, you might have been going there for a neck problem, but they adjusted your back as well, and you don't remember that. And you say, well, I never had back pain. Well, you say, they ask, well, were you ever adjusted for it? You don't remember. And then they use it against you, right? The insurance company is going to use that against you.
Pre-existing conditions, even if they exist, are not the end of your opportunity for justice. It's more about preparation to present your case on an individual basis in the best light so the insurance company gives you a fair offer.
And that's it. I mean, it's not a death knell for a case, because most of us have had injuries in the past. And sometimes injuries aren't even related. We see that, they've had a foot injury and they're here, the accident is a back injury. The important thing is to reveal all of that stuff so we can talk about all the injuries and say, that's not related, because the reality is a lot of that stuff that's not related is never going to come into trial.
Right.
And we know how to do that because we try cases. And there's what's called motions in limine. We can talk to a judge and file these motions, say, Judge, this is not related, this should never come up, or even a previous accident where they didn't treat shouldn't come up. And we've made those arguments in front of judges and always won those. If there's a previous accident, you didn't treat for it, that shouldn't come into evidence. The insurance company wants it into evidence, of course. They want to say, oh my gosh, you were in a worse accident 10 years ago, but we say, Judge, they didn't treat. What does that have to do with anything? We're here about this crash. The problem is that we say every case they're going to throw pre-existing injuries out there, and they will. And you might be thinking, gosh, I went to a chiropractor 2 years ago, or I went to a doctor or an orthopedist a couple years ago. How's that going to affect my case? The issue is, did you recover? Because a lot of times you went a couple times and you recovered and you were fine and it wasn't a problem. And the insurance company still loves that record. The reality is they love that record and they want to talk about it. The best thing we can do is say, okay, you went to the doctor 5 times and you got better, especially if the records, if you're going to a chiropractor, a lot of times they document, you started at a 5, you got better, you got to a 2, you got to a 1, and then if you didn't go back after you were a 2 or 1, the indication is that your injury got better. And we can differentiate that. But that's the important thing about looking at records, right?
Absolutely. And we always go through those records, or certainly our staff does, as well as the attorneys. But definitely to prepare the client for deposition, we go through all the records so that they're prepared to explain any inconsistencies or what the insurance company will contend are inconsistencies.
And I think one of the different approaches that we have than a lot of firms is, a lot of firms are tied to certain doctors. And that's just the reality of the way they work. You say, I like my doctor, I like my orthopedic, I like my chiropractor, and they say, well, no, we need you to go here. We don't like that approach, because here's the thing, your previous doctor is in the best position to say how you were before the accident and how you were after the accident, especially if you've been treated just recently. They can say, well, gosh, I saw the person 3 months ago and they were doing really well, and here's my records, and I can testify to that because I'm not reviewing, because what happens in the other instances, they say, well, I reviewed these records and I think they were doing better and I rely on what they say. But that doctor can say, I was there, I was touching the person, their knee was better, their back was better, the spasm went down. And that's important. So we always tell people, if you like your doctor and they've helped you get better in the past, that's really the right person to go to.
Precisely. And we do not doctor shop. We don't try to direct our clients to doctor shop. And we'll work with literally any doctor in the area. And we've had good success with that approach.
And what I've never understood, if you like your doctor and your doctor got you better, wouldn't that be the place you'd go? I mean, that's what I tell them. Like, that not only does it help, and in my opinion, it helps our case.
Sure.
Because one of the things we differentiate if we go to trial is, hey, they're hiring a doctor to see you one time. He's just reviewing records. How can he rely on those records? Now, if we've sent you to another doctor, we can't do that.
Right.
We can't say, we've seen him before, we've seen him after, and that's important. If they made you feel better and they're going to help you, we can use that to our advantage, because A, they may make you feel better again, and that's a great result for you. But if you're still in the case, we can actually use that doctor's testimony and that evidence very strongly in the trial. The insurance company is going to do everything to minimize your injuries. They're going to say they're all pre-existing. And a lot of times it's complicated. When it's complicated, you need to go to an experienced attorney. You need to have the attorney look at your case, not just a case manager, not just a paralegal. You need the attorney to look at your case, go through all the facts, and get through that case. So call us at Beers & Gordon. You'll talk to an attorney. We'll look at all those facts. Call us at Beers & Gordon, 407-862-1825, or look at our website, beersandgordonlaw.com.